Sorry about that. Welcome to Esquire Group's presentation on expatriation. My name is Jimmy Sexton. I'll be your presenter today. To start off the presentation, this presentation is for information purposes only. It's for educational purposes. It's not specific tax or legal advice. Everybody's circumstances are different, and everybody should seek advice for their particular situation. A little bit about my background. I have a Bachelor of Science in Business Administration with an emphasis in finance, a JD, and an LL.M in International Taxation. I'm the president of Esquire Group. It's an international tax advisory firm that I helped found in 2005. We currently have offices in Las Vegas, Phoenix, Vienna, Frankfurt, and the United Arab Emirates. We specialize in international taxation, including tax issues facing citizens, resident aliens living abroad, expatriation, investing or doing business abroad, or foreign investment in the U.S. I speak German and English fluently, and if you're interested in knowing a little bit more about me, there's a link to my profile at the bottom of this slide. In case any of you have not noticed yet, this presentation is available for download from the GoToWebinar site. So you have access to these slides and the entire presentation. We'll also be posting a recording of this presentation on GoToWebinar site, on our website, as well as our YouTube channel. So you'll be able to access it at any time. We'll also be answering questions at the end of this presentation. So if you have any questions in your GoToWebinar control panel, you should be able to type those in. They'll pop up on my screen, and I'll answer most of them to the best of my ability at the end of the presentation. Please try to keep your questions general in nature. Don't ask specific questions about your particular situation. So some of the topics that we're going to cover today, we're going to talk about what expatriation is, how you do it. We're going to talk about some of the facts relating to expatriation, some of the things you should be aware of. We'll talk about the tax consequences of expatriation. We'll talk about tax compliance, when you expatriate, after you expatriate, and we'll also talk about the benefits of expatriation tax planning. So we'll go ahead and jump right into it. So what is expatriation? So expatriation applies not only to U.S. citizens, it can also apply to long-term residents. So for U.S. citizens, expatriation is pretty straightforward. It's relinquishing U.S. citizenship, so basically giving up your U.S. nationality. For permanent residents, that is green card holders, they can also be considered to expatriate. And this is if they cease to be a long-term resident. A long-term resident is someone who has been a lawful permanent resident of the U.S. in at least 8 of the last 15 years, ending the year the long-term resident status ends. So basically, if you're a green card holder and you have been for 8 of the past 15 years, the tax rules regarding expatriation and some of the other rules regarding expatriation are going to apply to you equally as it would to a U.S. citizen giving up their passport. That's something a lot of green card holders are not aware of, and we'll get into a little bit more detail about how you effectively expatriate both as a citizen and a permanent resident here a little bit later in the presentation. So how do I expatriate? So it's different whether you're a citizen or a long-term resident. So if you're a U.S. citizen, you expatriate by committing or performing an expatriating act. And I've highlighted the most common expatriating facts here. And this isn't a comprehensive list of expatriating facts, but I think that it does give a good overview of what the most common expatriating acts are. So obtaining naturalization in a foreign state upon one's own application after attaining the age of 18. So that's pretty simple. If you are naturalized in another country after the age of 18 and you yourself applied to be naturalized in that other country, then that would be considered an expatriating act. Taking an oath, affirmation, or other formal declaration of allegiance to a foreign state or its political subdivision after the age of 18. This is normally related to a job, security clearances, things like that in a foreign state where you'd have to make an allegiance to them. So if you did that after the age of 18, that would be considered an expatriating act. Entering or serving in the armed forces of a foreign state engaged in hostilities against the U.S. or serving as an officer. So if you were serving in a military for a country that was at war with the U.S. or as an officer in a foreign military, then that would be considered an expatriating act. Accepting employment with a foreign government after the age of 18, if having the nationality of that foreign state or if an oath or declaration of allegiance is required in accepting the position. So a lot of times these are like working in a foreign embassy, things like that. This would be considered an expatriating act. Probably the most common expatriating act is renunciation of U.S. citizenship. So formally renouncing U.S. nationality before a U.S. diplomatic or consular officer outside of the United States. This is what most people that give up their United States citizenship do. It's also possible to renounce your U.S. nationality within the U.S., but it's only possible in very limited circumstances. For example, if the U.S. is in a state of war, and the Attorney General would have to approve it and prescribe what the method of renouncing within the U.S. would be, or being convicted of an act of treason against the U.S. or for attempting to overthrow the U.S. government, that would also be an expatriating act. So the reason we've gone through the expatriating acts is that the way that you expatriate is by performing an expatriating act voluntarily and with the intent of relinquishing your U.S. nationality. So if you performed one of those acts on the previous screen and you did so voluntarily and with the intent of relinquishing U.S. nationality, then you would be considered to have expatriated. One of the caveats here is that the intent portion of expatriation and relinquishment is not automatically established in these four instances. So naturalized in a foreign country, taking a routine oath of allegiance to a foreign state, serving in the armed forces of a foreign state that is not engaged in hostilities against the U.S., or accepting a non-policy level employment with a foreign government. So in these four instances, the intent is not automatically inferred. So if you performed one of these four acts and you intended that by doing so you would relinquish your U.S. nationality, you have to affirm that this was your intent in writing to a U.S. consular officer, that the act was performed voluntarily with the intent to relinquish. So a perfect example of this is, let's say, a 25-year-old person on their own application is naturalized in Germany. If they wanted, if their intent was that by becoming a German citizen, that they wanted to relinquish their United States citizenship, they would need to inform a U.S. consular officer in writing and affirm that they obtained the German nationality with the intent of relinquishing their U.S. citizenship. Otherwise, it's assumed that you performed the potentially expatriating act without intending to relinquish. So if you performed one of these acts and you did not intend to relinquish your U.S. nationality, then you don't have to do anything. But if a U.S. consular officer were to ask you if your intent was to relinquish your U.S. nationality, then you would need to just go ahead and affirm that it was not your intent to give up U.S. nationality. So going back to the same example of taking on German citizenship, let's say you take on German citizenship, and then the next time you go to renew your United States passport, the U.S. consular officer sees that you've become a German citizen in the meantime, and he might ask you, hey, when you were naturalized as a German citizen, did you do so with the intent to relinquish your U.S. citizenship? And you would just answer, no, I didn't. I want to keep my U.S. citizenship, and you would be able to. There's also certain actions that by taking those actions after performing the potentially expatriating act, that you would be assumed that the intent was to keep your U.S. citizenship. So, for example, if you voted in the United States or used your U.S. passport after having performed a potentially expatriating act, that would be evidence that you intended to not relinquish your U.S. citizenship. So going back to the same example we've been talking about with obtaining German citizenship. So if you obtained German citizenship and then you went and used your U.S. passport thereafter, it would be assumed that since you used the passport, you weren't intending to relinquish your U.S. nationality. Some facts that are important to keep in mind when expatriating or relinquishing your U.S. citizenship is that you lose all rights and privileges associated with U.S. nationality. So, it's the right to live in the United States. It's the right for protection from the to be protected by the United States. Things of that nature. Expatriation is irrevocable. There's no take back. So once you've expatriated, it's a done deal. One of the questions that I get asked a lot is, especially by parents, is, well, can I expatriate my kids? And the answer is no. Expatriation is something individual to each person, and you have to be competent and understand the consequences of expatriation in order to be able to do it for yourself. So a parent or a guardian cannot relinquish for a child or incompetent. Every U.S. embassy is sort of allowed to set their own rules regarding relinquishment of U.S. citizenship, about expatriation. And most embassies have an age of 14. So normally somebody would have to be 14 in order to expatriate themselves. It's also very important to note that before expatriating, you'd want to make sure that you have another nationality, otherwise you'd be stateless. A lot of people seem to think that by expatriating, it's going to solve their past non-compliance with U.S. taxes or failure to enter the selective service. That's not the case. It has no effect on your tax or military obligations up until the time of expatriation. I can't tell you how many people I've seen that that were completely unaware of their requirement to file U.S. taxes because they had lived abroad for many, many years. And then their solution was, well, I'll just go expatriate, and then it's not going to be a problem anymore. Wrong, because you were still a U.S. citizen. You still had these obligations up until your date of expatriation. So you're still liable for it. And expatriating is not going to solve that problem. Expatriating also does not give you any protection from prosecution for crimes committed in the U.S., nor does it alleviate financial obligations incurred in the U.S. or by U.S. citizens abroad. So you can't really use expatriation as a way to get away from your responsibilities vis-a-vis the United States. So now we'll talk a little bit about how long-term residents expatriate, because the process is quite different because they're obviously not U.S. nationals. So essentially, long-term residents expatriate by abandoning their permanent resident status by filing Form I-407, commencing to be treated as a resident of a foreign country with which the United States has a tax treaty, does not waive the benefits of those treaty, and informs the IRS by filing Forms 8833 and 8854. So the second point is essentially, we'll go back to using the example of Germany. Let's say a German citizen with a green card decides to move back to Germany, and there's a treaty between the United States and Germany, and this green card holder decides that they want to be treated as a tax resident of Germany. They could file Form 8833 and 8854, not waive the treaty benefits, and then the U.S. would view them as having expatriated. Another way for long-term residents to expatriate, which really isn't something that's voluntary, is if their permanent resident status has been revoked or administratively or judicially determined to have been abandoned. Now, one thing that I do want to address in terms of the first point that I made about abandoning permanent resident status by filing Form I-407, there's a very common misconception that if you just stop using your green card, that's what's going to terminate your tax responsibilities to the United States. I've seen other people think that it's the expiration date of the green card that is going to end your tax responsibilities to the United States. Neither one of those are correct. So you could have a green card that is completely useless for immigration purposes, is invalid for immigration purposes, is expired for immigration purposes and can't be used. But until you file Form I-407, you're still going to be considered a tax resident by the IRS. So filing that Form I-407, if you're a green card holder, is very, very important, because that's going to determine when your tax responsibilities to the United States stop. With some of the miscellaneous facts, one miscellaneous fact, if you're a long-term resident, you expatriate, is that basically you lose the right to permanently reside in the United States. It's about the only thing that, the only real non-tax consequence to expatriating. So now we're going to talk a little bit about what most people are most interested in regarding expatriation, and that is, what are the tax consequences of expatriation? Much like everything with tax, the answer is it depends. And in this case, it depends on whether or not you are a covered expatriate. So let's talk about what a covered expatriate is. So there are basically three criteria in determining if somebody is a covered expatriate. And this applies equally to U.S. citizens and long-term residents that are expatriating. So the tax consequences are identical for long-term residents and U.S. citizens. So if you have a net worth of $2 million or more, you're a covered expatriate. If you have an average annual U.S. income tax liability of more than $161,000 for the 5-year period before expatriation, you're a covered expatriate. Two things I want to point out with the second point: it is not $161,000 in income; it is $161,000 in tax, so in income tax. And the way that number is figured is essentially you add up all the income tax you paid for the 5-year period prior to your expatriation, you divide it by 5, and if that number is greater than 161, then you're a covered expatriate. The third and final way you become a covered expatriate is by failing to certify compliance with U.S. tax obligations for the 5-year period prior to expatriation. So you could have a net worth of less than $2 million, have an average income tax liability of less than $161,000, and would otherwise be what's known as a non-covered expatriate. But if you aren't in tax compliance, you're going to be considered a covered expatriate. And we're going to talk about the consequences of being a covered expatriate in a couple of minutes here. But this is the one that we see people fail at most commonly. Either their tax returns weren't done right, or they were one of these people that didn't know they were supposed to be filing, or thought that they were going to solve their tax problems by expatriating and ran to the embassy and immediately expatriated. The issue with that is you're then a covered expatriate, and that comes with some consequences. There's two exceptions to this covered expatriate status. So if you're a dual citizen at birth and you continue to be a citizen of that country and taxed as a resident of that other country, and you have not been a resident in the U.S. For more than 10 of the last 15 years, then you would be exempted from the $2 million threshold and the $161,000 income tax liability threshold. So if you met that exception, even if your net worth was more than $2 million or your average income tax liability was more than $161,000, you would not be a covered expatriate. Mind you, the failure to certify the tax compliance, it's not an exception to that. So it's very, very important to be in tax compliance before you expatriate. Then going back to the exceptions, the second point is if you relinquish your U.S. citizenship before attaining the age of 18 and a half, and you were not a U.S. resident for more than 10 years prior to relinquishing citizenship, then you would also not be a covered expatriate. Again, this exception is only an exception to the first 2 points of being a covered expatriate. If you fail to certify tax compliance, you're still going to be a covered expatriate even if you meet either of these two exceptions. So again, the tax compliance is very, very important. So if you are a non-covered expatriate, you can basically expatriate without any tax consequences at all. You expatriate and essentially you're just like any other non-resident alien, like any other foreigner. If, however, you're a covered expatriate, there's going to be some tax consequences that can be somewhat harsh depending on your circumstances. The first is a mark-to-market tax on unrealized gains. So a mark-to-market tax essentially works like this. Let's say you bought a house for $500,000, and now it's worth $800,000, and you expatriate. You have a built-in unrealized gain of $300,000. You paid $500, it's worth $800, your gain is $300. So essentially, what you have to do is figure out what your basis is, essentially what you paid for all of your assets and what their fair market value is. And if there's any unrealized gains, those are going to be subject to tax. You do get a $393,000 gain exclusion. So you're actually only going to pay any tax if the gain is more, if the unrealized gain is more than $693,000. Also, any deferred compensation items, these are essentially like IRAs, 401ks, annuities, pensions, life insurance, are going to be treated as distributed on the day before expatriation. So essentially, everything in deferred compensation accounts is going to be included in your income and is going to be taxed. Possibly two of the harshest tax treatments of covered expatriates are the gift and estate tax. So typically in the United States, it is either the donor, the person giving the gift, that pays the tax, or the estate of the person who died that pays the estate tax. And the recipient of the gift or inheritance doesn't pay any tax. If, however, the gift or bequest in inheritance is received from a covered expatriate, the rules get reversed, and it's the recipient of the gift or inheritance that has to pay the estate tax or the gift tax. In 2016, the estate of gift tax is 40%. So this creates a few problems. I mean, one, and this is a very real example, and one that we've seen. We haven't seen it in practice yet because these rules regarding the gift and estate tax are very new. But the problem is easily foreseeable. Let's say you have an American woman that marries a non-U.S. citizen spouse, and they have a couple of children. The spouse later takes on, the wife, the American wife, later takes on the husband's nationality, and the wife decides, for whatever reason, that she's going to expatriate. And let's assume further that the wife is a covered expatriate. So now you have the wife who's a covered expatriate. Both parents are no longer citizens. The two children received U.S. citizenship from their mother at birth. And let's assume that one of them's 8 and one of them's 10. So the children don't have any possibility to expatriate because they haven't reached age 14, and a parent can't expatriate a child. Now what happens if the mom dies and leaves part of her estate to her children? The children are going to have to pay 40% estate tax on the inheritance that they received. So that's problematic. And not only is it problematic, but it's further complicated by the fact that it's the person receiving the gift or inheritance's responsibility to determine if the gift was received from a covered expatriate. So how are the kids going to determine that? I mean, essentially, in order for a recipient of a gift or inheritance would have to know, A, that the person they received this from expatriated. B, they would have to know whether or not the person was a covered expatriate or not. And that would require some pretty intimate details of that person's finances, of their taxes, and things of that nature. One of the things that we always advise our clients to do is to put a packet together, and this is something that we help our clients with, documenting the expatriation for their heirs, so that their heirs are able to prove, whether or not this gift was received from a covered expatriate, because that's going to be very, very important. You'll also notice in the gift and estate tax bullet points on this slide that I put somebody who receives gifts directly or indirectly, or receives inheritances directly or indirectly. The reason I put directly or indirectly in there is because directly is pretty simple, right? Mom dies, she leaves daughter the inheritance. That's a direct inheritance. Or mom gives daughter money, that is a direct gift. Indirectly would be, some people have come up with ideas of, well, what if I put the money in trust and the trust gives it to them? Or what if I give it to this person and then that person gives it to them? That would be indirectly. So trying to funnel it through another means isn't going to work. The IRS beat you to the punch. They thought of that already. The final point on the covered expatriate we've already covered, which is that it's the recipient of the gift or inheritance that's responsible for determining if the gift or inheritance was from a covered expatriate or not. So again, that's going to be very, very important, especially for people who expatriated and have heirs that they want to leave some of their U.S. estate to. They're going to need to make provisions for providing them with documentation showing whether or not they were or were not a covered expatriate. Some of the things to think about when you are expatriating, so some other tax consequences are, one, you lose your lifetime gift tax exclusion. So, for example, in 2015, the lifetime gift tax exclusion was $5.43 million. You lose that. So that's gone. You also lose the lifetime estate tax exclusion. If you continue to have U.S. income after you expatriate, it could be subject to withholding tax, depending on the type of income it is and the country that you live in, and whether or not there's a tax treaty with the United States and what that tax treaty says. Some of the most common types of income that are subject to withholding tax are interest, dividends, pensions, and Social Security. So now we'll talk a little bit about what you have to do to stay in tax compliance relating to your expatriation. So for the year of your expatriation, you have to file a dual status tax return, and you have to file Form 8854. Now, a dual status tax return is kind of a complex beast. It's essentially a 1040 for the part of the year that you were a U.S. citizen, and then a 1040 NR for the entire year. And then the 8854 is your expatriation statement that is basically your official notice to the IRS that you've expatriated, and it contains various types of information. Now, one of the things that's really important to keep in mind about the Form 8854 is that failure to file the 8854 results in you continuing to be taxed as a U.S. citizen or permanent resident until you file it. So if you don't file the 8854, then your tax obligations in the U.S. don't stop. Your tax obligations will continue just as if you were a U.S. citizen or resident. There's also a penalty associated with Form 8854. It's a $10,000 penalty for failure to file it, not including all the information that's required or providing incorrect information. Also, if you continue to receive any income from within the United States, then it's possible that you'll have to file a U.S. income tax return to report that. It depends on whether or not the income was subject to withholding tax and if full withholding was done, or if it's from a U.S. business, that would determine whether or not you are required to file a U.S. income tax return. Expatriation planning, I think, is really, really important, and I think it's something that a lot of people don't do, especially for potential covered expatriates. A really simple example of one way that covered expatriates can take advantage of tax planning is we're talking about the loss of the lifetime gift tax exclusion. Let's say, for example, that the covered expatriate knew that they wanted to leave a certain amount of money to U.S. heirs. They could use their lifetime gift tax exclusion prior to expatriation to form an irrevocable trust in the United States to provide for those U.S. heirs. So this way they'd be utilizing their lifetime gift tax exclusion before losing it at expatriation. They then wouldn't have to leave any inheritances to those heirs because they already made a provision for them with this U.S. trust prior to expatriation. And then they can use the remainder of their assets for provision of heirs that are not U.S. persons and that would otherwise be subject to inheritance tax for receiving an inheritance from a covered expatriate. So that's just one small example of some of the things that can be done with expatriation planning. And with proper planning, a lot of times the tax consequences of expatriation can be greatly reduced and in some instances even eliminated. In some instances, proper planning can help an otherwise covered expatriate become uncovered. So, one of the most common ways that a otherwise covered expatriate becomes uncovered is with being in tax compliance for the 5 years prior to expatriation. So, by having somebody qualified in international taxation review your prior tax returns, make sure that everything was in fact done properly, and correcting them, amending them if they were not, could be the difference between being a covered expatriate or non-covered expatriate. So, that's one thing to be very careful of, and which goes right into my last point, that it's imperative to ensure that you're in full tax compliance prior to expatriating, especially for those that would otherwise be uncovered expatriates, because the not being able to certify tax compliance could certainly trigger you being a covered expatriate. So that brings us to the end of our presentation and question time. So we'll go ahead and answer questions here for 10 or 15 minutes before breaking this off. If anybody has any questions or would like more information about myself or Esquire Group, there's our contact information as well as our address on the web. So the first question is the $2 million threshold per person or for a family? It's a very good question. The $2 million threshold is per person. So expatriation is individual. So the $2 million threshold applies individually. So if you had a husband and wife, each the husband and wife would have a $2 million threshold. If everything was owned jointly, you would basically divide the assets 50-50. One caveat to that is even though you do that with assets in the $2 million threshold, as far as the $161,000 income tax liability threshold, if you file a joint tax return, you don't get to split that in half. That is per family. All right. And any other questions? All right, well, I don't think there's any other questions, so I'm going to go ahead and end the webinar now. Thank you very much for attending. We really appreciate it. Bye-bye.